service providers, staff and educators in different parts of Australia. This is a webinar around legislation changes relating to child swapping in family daycare. My name is Nikki Spalding and I'm presenting this webinar from regional New South Wales. However, I will be supported by a small team of competent people in Sydney. How the webinar will therefore work is that I'll go through the series of slides that you'll see in front of you, and you'll be able to read through them as I do, and then I'll make additional comments with each slide as well. Because I can't actually control the movements or the directions of the slides, Magda in Sydney will be working off my prompts with that. So, you know, good teamwork, and I'm sure we'll get through the hour fairly smoothly. The Family Daycare Services Education and Support Project is funded by the Department of Education and Training. It is managed by New South Wales Family Daycare Association. The project has to date included research, surveys, sector consultation, peak body collaboration, publications, information sessions, a website, resources, service support, webinars, newsletters and tools. Some of you, you know, again in different parts of Australia may have had access to that information, attended other webinars or attended training sessions, which is great, but we would direct you to that actual website if you are looking for more information. A copy of the brochure relating to child swapping is also available on the Education and Support Project website. It's not available in hard copy, but yes, it is available now and you can access it as you wish. Following this webinar, an evaluation form will be emailed to you, and I think it's fairly promptly after the webinar is completed as well, you know, maybe within the next hour or so. You know, if you could complete it, we would appreciate it because we do take on board the feedback that we get. Magda, we might move to the next slide, please. Okay, again, the legislation changes relating to child swapping in family daycare is what this 1 hour session will be about. The next slide refers to I suppose the disclaimer for this webinar as well. This webinar provides general information about the legislative changes. It does not constitute legal advice. You may wish to seek your own legal advice about your obligations under the changes. This webinar is built on publicly available information provided by the Department, and it is not New South Wales Family Daycare's interpretation of the legislation. You may feel that some of the information is repeated today throughout this session, but this is just to avoid any misrepresentations of the legislative changes that have come about. Now, we are happy to take questions today, and we will ask the Department for any answers if the questions are generic in nature, and particularly if we don't feel that we can answer them here and give you enough information to go on. Although you'll notice throughout the session, and probably too when I answer any questions, we'll be directing you back to the DSS website where there are frequently answered questions, and also to the email address where you can talk about your specific situation. The questions may be addressed in the frequently answered question area, the frequently asked, question area on the DSS website. As I said, there's already one available to you and it is updated as time goes on. As all participants are muted throughout this session, we ask that you type any questions in the dialogue or comment box on your screen. At 3 different intervals throughout the session, I'll pause and ask Magda to relay to me any questions which have come through. Please be aware that your specific situation may need to be clarified by a department representative and not in this general discussion forum. So in that case, I will direct you to the email correspondence with the department, but again, you can also access the frequently asked questions on the DSS website. The next slide refers to the Australian Government having made changes to family assistance law affecting childcare benefit approved family daycare services. The changes have been applied from the 12th of October of this year and are intended to end child swapping in family daycare. So this presentation aims to inform family daycare service providers, staff and educators of changes to the Family Assistance Law which came into effect on the 12th of October. Changes to the Family Assistance Law in 2015 have impacted on the care arrangements and practices of some educators. Child swapping is unique to the family daycare sector, and about 90% occurs in family daycare services identified as being at high risk of non-compliance. So the practice is contrary to the intent of Family Assistance Law, which envisaged family daycare educators would not be eligible to receive childcare assistance for their own children while caring for other people's children as a family daycare educator. The child swapping integrity measure strikes a balance between the need to address child swapping practices across the sector while safeguarding legitimate family daycare operators and the families who depend on them. Unfortunately, there have been unscrupulous practices in the family daycare sector. This has led to negative publicity in the press with headlines such as crafty childcare fraud, dodgy family daycare, childcare payment, rorting and the like. We would all agree that this does not serve the purpose of raising the profile of family daycare in the community. The family daycare sector provides quality care and education to more than 100,000 Australian families, and this is the information that we want shared. It's therefore important that legislation is clarified and service providers and educators know their responsibilities in light of this legislation. The next slide, please. Magda refers to actually like a definition, what is child swapping? Child swapping is a practice where a family daycare educator or their partner receives childcare assistant payments for a session of family daycare provided to their child on the same day that they themselves provided family daycare. An example of child swapping would be a family daycare educator offers care in her home Monday, Tuesday and Wednesday each week. She's organised care for her 4-year-old at a fellow family daycare educator's service or home on Monday to Wednesday. The educator is claiming childcare payments for the 3 days her child is in family daycare with the other educator. So this practice is not allowed except in specified circumstances. And we'll talk more about those circumstances as we go through. The next slide relates to who's affected by the changes. These changes affect approved family daycare services. They also affect family daycare educators and their partners, as they are not entitled to receive a childcare assistant payment for their children in family daycare on any day that they work as a family daycare educator, except again in some specified circumstances. So there are responsibilities on family daycare service providers and on individual educators. So this will be explained in more detail as we move through the presentation. The next slide refers to eligibility. Family daycare educators and their partners are not entitled to receive childcare assistant payments for their own child's session of family daycare if, on that same day, the family daycare educator provides family daycare for an approved family daycare service, except again in specified circumstances. So the following two are scenarios that amount to child swapping as per the new changes. A, an educator providing daycare service on the same day her or his child is being cared for by another educator. Or B, a partner of the educator is providing daycare service on the same day that his or her child is being looked after by another educator. Family daycare educators can still claim childcare assistance payment if they place their child with other service types such as long daycare, but not family daycare. Educators can continue to use family daycare for their own children. However, an educator or his or her partner are not eligible to receive childcare assistant payments for their child on the day an educator is providing daycare service to other children, except in the specified circumstances. Under the integrity measure, family daycare educators can continue to use family daycare as their care service type of choice for their own children. However, on a day an educator is providing family daycare to other children, they and their partner are not eligible to receive childcare assistance payments for their own children, except in these specified circumstances. The next slide also speaks of the key changes to the family assistance law, and in particular checking family daycare educator status. The family daycare service will be required to ask eligible individuals if they or their partner are a family daycare educator. An approved family daycare service must ask an eligible individual, so that would be the person who is entitled to childcare payments for a child enrolled for care by an eligible family daycare service, if they or their partner are a family daycare educator. So this could be a question that you place on your enrolment form, although this is just a suggestion. The approved family daycare service must also request to be informed if the eligible individual or their partner later becomes a family daycare educator. This must occur within 7 days of the care date. That is, the date the child is enrolled for care with an approved family daycare service, or the date that no one eligible determination comes into effect. Family daycare services must have checked family daycare educator status for all eligible individuals using the service on and between the 12th of October to the 19th of October of 2015, and also for each new eligible individual using the service after that within 7 days of the enrolment of the child. Service operators must review any information and requirements to ensure they're covered and comply with that period of time. Can I suggest to you that if you did miss that period of time, that you take great pains to follow up on it as soon as possible. The next slide actually, just before we go on, sorry Magda, if we could just go back one. No, sorry. Okay, sorry, confusing you, Magda. We will move forward. I'll just mention specified circumstances, but as I said, we will go into more detail very soon. The specified circumstances allow eligible individuals to claim childcare assistance payments for their own child's family daycare on the same day they or their partner work as a family daycare educator in an approved family daycare service. If an eligible individual who is or is the partner of a family daycare educator informs the approved family daycare service that specified circumstances apply, the approved family daycare service must request particular information and documents to substantiate the specified circumstances. Specified circumstances do not apply unless documentary evidence has been provided to the approved family daycare service. The approved family daycare service must request to be informed of any changes to information regarding specified circumstances. So this is in addition to the approved family daycare service requesting to be informed if the eligible individual or their partner becomes a family daycare educator. So in other words, if there are any changes, then the approved provider needs to be alerted and the correct records need to be in place. Okay, the next slide, more key changes to family assistance law, is the change of circumstances. Approved family daycare services must request to be informed if an eligible individual or their partner becomes a family daycare educator. If an eligible individual or their partner is a family daycare educator and specified circumstances apply, approved family daycare services must also request to be informed of any change in those circumstances. If the family daycare service provider becomes aware that the eligible individual or their partner is a family daycare educator and one or more of the specified circumstances exist, the family daycare service must request relevant information. So except where the family daycare service is receiving inclusion support subsidy, because the child is ongoing continuous assessment of disability, the family daycare service must request documentary evidence of the specified circumstance. The service will have the documentary evidence of receipt of inclusion support subsidy. For any of the specified circumstances to apply, documentary evidence must have been provided to the approved family daycare service. The next slide relates to record keeping. Approved family daycare services will be required to retain evidence of specified circumstances. They must also create and maintain a register of relevant information. If a family daycare educator has a customer reference number, CRN, allocated by the Department of Human Services, the approved family daycare service will be required to enter into the Childcare Management System, CCMS. In regards to online compliance, an approved family daycare service will ensure that for each of its family daycare educators who has a CRN, the approved family daycare service will enter the CRN for each family daycare educator as soon as the approved family daycare service's CMS register software allows. Okay, at this point, I'll ask Matt if any questions have come through, and I will do my best to answer them or to direct you to where you might find the answers.
Thanks, Nikki. We have one question. Do services need proof? They ask the families enrolled in their service if they or their partner are a family daycare educator.
To my understanding, yes, a service would need to have proof, and if you consider the level of accountability for both educators and particularly for service providers, I think this is the best way to go as well. Again, you could do that on the enrolment form, and if you're not doing it there, I think it's a matter of working out a system or some way of registering that information to show that you have had that conversation with the educators about their situation or the situation of their partners, and also in that same way making those that you speak with very, very aware of their obligation to pass on any information regarding changes to their situation. So yes, to my understanding, it would need to be that information is recorded, and within that, services might need to even consider how they update that information as well.
I've got another two questions.
Okay.
If a parent doesn't meet the specified circumstances, how do you do an enrollment for the child so they don't receive CCB or CCR when their parent is providing care when they are attending a family daycare service, and then allow them to receive the benefits on the remaining days that their parent isn't providing a service?
Okay, there seems, Magda, I must admit, when I can't actually read the question in front of me, there seems quite a bit in there. Can I just ask you to read that one again? And again, I'll do my best to provide, supportive information. Although I'm believing to, I will also be encouraging the service provider that's put forward that question, that they also have a conversation with somebody from the department. But could you just read that question again, please, Magda?
Yep. If a parent doesn't meet the specified circumstances, how do you do an enrollment for the child so they don't receive CCB on CCR when their parent is providing care when the children are attending a family daycare service, and then allow them to receive the benefits on the remaining days that their parent isn't providing a family daycare service?
Yeah. Okay, again, even listening to it the second time, I think there is a fair bit of information there that needs to be sorted through, and it could be quite specific to the service as well, and the situation of some educators with children that will be requiring care. Can I suggest that the service provider or the person who's put forward that question actually has a conversation that can be done via email, and we will have the email address up very soon within this session. So I think that's a good question to put specifically to a department representative.
I've got two questions relating to the CRN number or the CRN. If a family daycare educator doesn't have a CRN, are they required to obtain one? And the other question is, are the CRNs for all educators required even if they do not have their own children in family daycare?
Okay, look, again, without the specific information relating to CRN, and as we know, there's quite specific information and guidelines for CRN and obtaining any benefits and that. So what I'm going to suggest that service providers do is perhaps go to their handbook or again post specific questions to the department through that email address that we'll have up soon. I'm sorry I'm not able to give a qualifying answer on this, but I just don't feel that I am actually qualified to do it and be confident that it is exactly correct information at this stage. So that's why I think I will defer that one if possible.
That's all the questions for now.
Okay, great. Thanks, Magda. We'll keep going then, and as I said, there'll be more opportunities for putting questions through. Okay, the next slide actually relates to the specified circumstances that we've alluded to. The specified circumstances are where the child has been diagnosed as having a disability or is undergoing continuous assessment of a disability. The child lives in a remote or very remote area within Australia. The family daycare educator is required to work for at least 2 hours other than for an approved family daycare service, and the family daycare educator is required at a particular time and on the same day they work as a family daycare educator to attend particular education or training on the care day. So they're the specified circumstances, and as you can imagine, different service providers and individual educators will need more clarification and more specific information to support their circumstances and the decisions that are made around that. An educator can claim childcare assistant payments under specified circumstances. Their child has been diagnosed with a particular disability or medical condition or is in the process of diagnosis, and the service is receiving inclusion support funding for the child. The educator lives in a remote or very remote area. There is more information about the specifications for remote or very remote that is available on going to the DSS website and looking in the area of family daycare, and it may again even then suggest that you look on the Australian Bureau of Statistics website for specific information about those mapped areas. So yes, and again, because it will be quite specific, and individuals and service providers will need to have that information perhaps when they're applying for specified circumstances. The educator's child needs family daycare because the eligible individual or their partner, who is a family daycare educator, have to work for at least 2 hours in another job that is not as an educator or for a family daycare service in another role on the care day. The educator is enrolled in a program or course of education and training towards a qualification at Certificate 3 level or above by a registered training organisation such as a TAFE, and be engaged in activities for the purposes of the program or the course they're enrolled in. So that might be attending the registered training organisation. On the care day at a particular time, and on the same day they also work as a family daycare educator. The next slide. The specified circumstances do not apply unless there is documentary evidence of the specified circumstance. In the case of the disability specified circumstance, if the child does not yet have a diagnosis and is undergoing continuous assessment of a disability, the service must be receiving the inclusion support subsidy in relation to the child. and retain evidence of its approval to receive that payment. Specified circumstances only apply when documentary evidence is provided to the approved family daycare service. The service will need to retain the documentary evidence and also keep a register. And from memory, I think it was 36 months, therefore 3 years that evidence had to be maintained by the service. The child must have been diagnosed by a medical practitioner or a registered psychologist as having a disability or medical condition listed in the legislative instruments. To ensure consistency, these are the same conditions used to assess the eligibility for the Inclusion Support Subsidy. Inclusion Support Subsidy, or ISS, assists eligible childcare services to improve their capacity to include children with ongoing high support needs. The assessment of an application for ISS is based on an eligible childcare service supplying documentary evidence that the child is undergoing continuous assessment of disability. It's an objective measure that there is genuine need. ISS eligibility ensures that people with a genuine need are able to child swap and provides an independent verification of their eligibility through an existing government-approved program. The Inclusion and Professional Support Program, IPSP, provide extra support to care for children with a disability. So for more information again regarding IPSP or ISS, you can also go onto the DSS website. More information is on the next slide regarding specified circumstances. In each of the other specified circumstances, the individual must provide relevant documentary evidence to the approved family daycare service that provides care to the child. Where specified circumstances exist, the approved family daycare service must retain at least the documentary evidence and keep a register of relevant information. The approved family daycare service must request to be informed of any changes to information regarding specified circumstances. This is in addition to the approved family daycare service requesting to be informed if the eligible individual or their partner becomes a family daycare educator. And again, we can only stress that family daycare educators have a responsibility to inform their service provider of any changes, and the service provider also has a responsibility and is accountable for following up on that information and recording that information. The approved family daycare service will, within 7 days of being notified that inclusion support subsidy is no longer being paid in relation to a child, record this fact and any other relevant information in the register in the form approved by the Secretary. Because this is kind of the end, I suppose, of that specified information around those particular circumstances, I'll ask Magda again if there's any questions that have come through.
Thanks, Nikki. I have a question about the 2 hours that educator needs to work. Is that 2 hours per week or per day?
To my understanding, it's 2 hours of paid work on that day, on that specific day that they're also looking to have their child in family daycare and also access CCB. So yes, 2 hours of paid 2 hours of paid work on the day. But again, can I suggest that if anybody has further, questions or needing more clarification, there is more information on the DSS website. So it's www.dss.gov.au/FDC. But again, that will come up soon, and there's a variety of information that will be available to services if they haven't already accessed it.
The next question is, does it have to be a paid job? Can it be volunteer work?
Again, Magda, with the information that I've looked at that's available to us on the website, and again, this is information that's available to all educators and service providers, and we really encourage you to make sure you have looked at all of that information and have an understanding of it. It is 2 hours of paid work. If service providers feel that they need further clarification on that, I can only encourage them to actually, perhaps use the email address and pose that question to a department representative.
Another question. Just to clarify, if an educator is attending training for their certificate 3 or to do first aid, the educator can place their child into care and claim CCB and CCR for that day?
Yes, it would seem if they are, I'll take a step back to the different components, I suppose, of that question. The minimum qualification that is being recognised is a certificate 3, so therefore I would think if the first aid was within the requirements of the certificate 3, as in needed to obtain the certificate 3, I would think that would then work to suit their purpose, I suppose. Again, if you need clarification, do look up the information in the frequently asked questions or contact a representative. So certificate 3 is the minimum requirement. The educator may, under the specified circumstances, be able to access CCB on that particular day that they have sought care for their child, but they've also been undertaking activities to support their certificate 3. So, as I said, certificate 3 minimum, accessing family daycare, also CCB under specified circumstances. If there is also documentation, evidence as such that's been provided to the family daycare approved provider, and that would all need to happen, I would believe, prior to this taking place, and also that any training activities are undertaken on that day of care.
Another question. Is it legal for the services to get an educator to sign a statutory declaration that the educator will not provide care to other kids while their own kids are cared for on the same day at family daycare?
I'm really not sure about that one myself, so can I just suggest to the service provider or educator that might have put that question forward that they do send an email to the through the email address that we're going to have up soon, and actually pose that question, because it's quite, again, specific information. It's not information that I've come across through my reading and my understanding. So therefore, again, I don't feel qualified to provide an answer.
I have one more question. What if educators are attending training on their days off?
Well, again, if an educator is attending training, and it would again have to be certificate 3 minimum through an approved RTO. If it's their day off, I don't see that. I'm just thinking if they're looking for family daycare on that day, but they're not providing family daycare themselves, I would think that they would still be able to access CCB. It's the child swapping legislation and guidelines come in, I suppose, when an educator is looking to access family daycare for their own child on a day that they provide family daycare themselves, in which case specified circumstances apply if there is evidence that they, yes, are studying, as I said, minimum certificate 3 through a registered training organisation and undertaking some activity on that particular day. So if it's their day off, I'm not, to my understanding, it's not child swapping. But again, if this is an educator posing the question, I think they need to clarify with their service provider. If it's a service provider putting forward this question, they may like to clarify that by looking on the DSS website and accessing the information that's available there, or sending an email to the department and asking about that specific situation.
All right, that's all the questions for now, Nikki.
Okay, thank you, Magda. Okay, so the next slide relates to records. How will records be kept? A registered template is available for approved family daycare services to record details of the specified circumstances, and this is available by visiting www.dss.gov.au/family daycare. In addition, an approved family daycare service must keep the documentary evidence of the specified circumstances. An approved family daycare service will be required to record in a register relevant information relating to specified circumstances. The approved family daycare service will be required to keep records which are provided to or created by the approved family daycare service which substantiate the specified circumstances. If you go onto the department's website, you'll see a link to that actual register template that's available, and I suggest that you do have a look at it. It provides an opportunity for you to move through, I suppose, the process of gathering that information and making sure it's recorded in the correct way. Again, the next slide relates to record keeping. Once an eligible individual has advised the service that specified circumstances apply, the service is required to ask for particular information and documents. So the department has developed the Family Daycare Services Specified Circumstance Information Request, which may be used to request information and supporting evidence of specified circumstances from eligible individuals. So the form is designed to help services comply with their obligations and assist eligible individuals to both gather the information and documentary evidence that your service has asked them to provide, and also understand the specified circumstances and the documentary evidence they need to provide your service in order to demonstrate their eligibility for childcare payments. Services are not required to use this form, however. Services may prefer to request the information and supporting evidence of specified circumstances by other means. Services, again, must keep all records created in making the information request. So, again, I can only direct you back to the information that the department has already supplied for us, and particularly in relation to that request form that they have put forward there, the Family Daycare Services Specified Circumstances Information Request, because it does, I suppose, again, assist you to work through the process of what information you may need, how you can go about gathering that information, even perhaps suggesting questions that you may ask of individuals, and then actually how that information should be recorded. So in other words, in accessing that, you actually have quite a bit of information that is specific on your at your fingertips. Okay, the next slide, what do service providers need to do? Operators of an approved family daycare service need to make sure they're fully aware of their obligations under family assistance law, including any new obligations the recent changes place upon them. So again, there's that encouragement, or probably even direction for you to go to the website, access that information, work through it, discuss it, I suppose, with the team that you work with, and also making sure that educators are also aware of their obligations to pass on information to you and update that information, and also provide any documentation if they believe they will be eligible in the future. The next slide refers to consequences of non-compliance. Sanctions may be imposed on approved family daycare services if they do not comply with one or more conditions for their continued approval. Sanctions could include suspension and cancellation of approval. For certain obligations, including the failure to keep prescribed records, non-compliance may lead to a civil penalty order being made or an infringement notice being given, or prosecution for a criminal offence. The Department will continue to crack down on non-compliance through random checks, forensic data analysis, suspicious claim investigations and other measures. The Australian Federal Government expects all educators and family daycare service providers to abide by their obligations as stipulated under Family Assistance Law and other relevant legislations. The penalties for non-compliance include suspension and cancellation of the service's CCB approval, financial penalties and perhaps prosecution. Key personnel may become the subject of criminal investigation. The Department's Childcare Compliance Team will be giving particular attention to compliance with these new rules. The next slide reminds us that service details must be up to date. Family daycare services must ensure they give the Department of Education and Training the full details of every educator who works for their service, including the full name and date of birth of the educator, the address where the care is being provided, the educator's phone number, the educator's unique educator ID, and the educator's highest relevant qualification. You must let the Department know when any of these details change. Service providers must tell the Department of Education and Training of any changes to the information given to them on the original CCB approval form. This is referred to by the Department as a notifiable event. Legally, you have to inform the Department of all notifiable events. For example, changes to the details of your original approval form, such as address, phone or email address, changes to your organisation or company's legal structure, changes in company directors, or changes to bank account details. There are penalties where the Department is not informed, including suspension and cancellation of approval. So there within that we're reminded, or service providers are reminded of their obligations. The next slide, again, service details must be up to date. You can update most of your service details via the Childcare Management System, CCMS, through your registered CCMS software. The next slide reminds us, though, you will not be able to report the following information through your CCMS registered software, and that will be the full name of the educator and their date of birth, the financial email address for the receipt of remittance advice, the bank account details, the number of places offered, and the changes to your service's legal entity. The next slide, thanks Magda. To report this information, you'll need to submit a form to the Department of Education and Training. You can find the forms on the Department's webpage under Notification of Changes to Your Childcare Services. Only someone that's been notified to the Department as key personnel or an authorised person for the operator of an approved service has permission to change the details the Department holds about an approved service. So again, we're reminded there that information does need to be updated, but it needs to be updated by key personnel or the authorised person for the operator. The next slide is about where service providers, educators can gain more information. So for more information, including a fact sheet regarding the new changes, you can go to www.dss.gov.au/family daycare. If you have any queries about these new legislative requirements, you can also email childswappingrule@education.gov.au. The information sheet, frequently asked questions, which have been recently updated, and an operational guide on the change, as well as the register of specified circumstances and the specified circumstances information request can be found on that DSS website. So I'll just go over again what's available to you there. It's the child swapping fact sheet. It's the operational guide, which steps services provided through the process of gathering and recording information. The information request sheet, the register or template register of specified circumstances, and also the child swapping frequently asked questions. Magda, can I just ask again, are there any questions?
Yes, I've got a few questions.
A few questions? Okay.
If the department turns up unannounced, can I ask them for the reason of their visit?
I'm actually not sure of that in so much as I'm thinking if the representative of the department does come to your service, they will let you know for what reason they're there and what information they may require while they're there. The person who's put that question forward may like to clarify that with the department by sending off an email to them. But to my understanding, if a representative is going to attend your service, they will be explaining to you, the reason that they are there and the information that they require.
Next question. Can an educator work for 3 hours in another job and then 6 hours as an educator on the same day and have their child in family daycare for the 9 hours, or just for the 3 hours they are working in another job? Sorry if you have answered this already. I had to answer the phone.
Okay. I understand, a lot of people are very busy, particularly at this time of year, so that's fine. No, it's not something I think I've addressed specifically. To my understanding, again, if an educator is working in another paid position that is not family daycare related on the same day that they provide family daycare but also require care for their child, they would be able to access family daycare and CCB for the period of time their child requires care, but keeping in mind there that the limits of hours that are already set. So again, I suppose different rules as such will apply, and family daycare service providers need to be aware, I suppose, of their obligations and their understandings of all of those things that come together. Again, whoever has asked that question might like to go on to the website. I'm just trying to think. I can't remember a specific example that spells that out directly. So you may like to pose that question to a representative, or again in the frequently asked question area, you might find the answer that you're looking for to support what I've just said.
One more question. How do I tell the department the educator's details through CCMS software or by email?
Well, it seems that some, as a couple of those last slides alluded to, there's some information that you can put forward or that should already be in place on the CCMS software, but there's some information that doesn't go in that area, in which case it needs to be addressed in another way. And I'll just try and go backwards with my paperwork and just have a look here. Okay, so it says you'll not be able to report the following information: the full name of the educator, the date of birth, the financial email address for the remittance advice, the bank account details, number of places offered, and the service's legal entity. So that information will need to be submitted on the form to the Department of Education, and you can find the form on the department's website and under notification of changes to your childcare service. So again, we'll direct that service provider or educator, probably service provider, I would think, back to that specific area to gain the information they need or the forms that they may need.
I have another question that came up. I think there's some confusion here about working on the same day or a number of hours. It is indicated as day, not session. So I am assuming that an educator cannot access family daycare if they were working for any period of time in family daycare on that specific day. in regard to the question asked earlier. Would this not be correct?
Okay, Magda, can I get you to read that question out again?
Sorry.
No, that's good.
It is indicated as day, not session. So I am assuming that an educator cannot access family daycare if they were working for any period of time in family daycare on that specific day. And this is in regards to the question about the 3 and the 6 hours. Would this not be correct?
Mm-hmm. Okay, well, again, going on the information that I have received and, you know, the information I've accessed through the website, the educator would need to be working more than a minimum of 2 hours in another paid capacity or position that is not family daycare related. So I suppose the specific hours of that, when, you know, what they would need to be clarified. So I understand that, you know, there may be some not necessarily confusion, but some service providers that will want to seek more specific information about that, and again, clarification on the situation that pertains to the educators within their service, because as we know, you know, family daycare, you know, can happen different times of, you know, a 24-hour period. So it's really going to, I suppose, depend on the specific situation. So can I suggest that perhaps the person that initially asked the question and any others who need that clarification have a look on the department website, and also, if need be, follow up with an email to the department and, you know, gain clarification from a representative.
That's all the questions for now, Nikki.
Okay. Well, the next slide. Thank you, Magda. This one shows you the cover of the brochure that's available to you online, as I explained. Presentation. It isn't available in hard copy, but it is available for you to access.
Nikki, this is Magda. I think your microphone may have dropped out.
Okay, now just unfortunately I was muted there for a while as well. But yes, Magna, just the final slide if it's available. Thank you. And thank you to Magna and the team up in Sydney, and thank you to those of you who have taken part in the session today. In the presentation, you know, I congratulate you on taking the time to seek more information, seek some clarification, and again, we would encourage you to continue with that. Access the information available to you, make sure that you're aware of your responsibilities and those of the educators that you work with, and again, seek clarification if you do need it on specific circumstances which relate to you or the educators in your team. Because I think at this stage it is important, because as we understand from all of this, we do have a high level of accountability. And again, you know, family daycare, as I mentioned in one of the earlier slides, you know, over 100,000 families in Australia access family daycare at any given time. So we want the message out there, and we want the profile of family daycare to be of, you know, quality care and education that's offered in homes right across Australia. And to do that, we need to be aware of the legislation, of our obligations, and we need to be, meeting them. Okay, so thank you again for taking part, and the best of luck to everybody.